I'll be over there, yeah.
But
Should get you on the video.
Yeah. I'll use this. Bend that over our way. Yeah. So whatever. And this is 5 to 7.
5 to 9.
Whenever you're ready, just let me know. All right, good evening, everyone. If I could get everyone to quiet down for just a brief moment, I wanted to go ahead and take this opportunity to welcome everyone to the Board of Supervisors chambers. I'm Pete Vanderpool. I sit on the Board of Supervisors and represent District 2, which includes the southwest part of Tulare County. I noticed several constituents here, and I thank you all for attending. This is, I believe, Government 105. Maybe more. Who's attended one of these sessions before? Please raise your hand. So you're back for more, so that means that they are good, and I really do thank you for your interest in serving Tulare County constituents as special district board members. I think it's a total fallacy that you're not able to receive the level of training that many of you need for these various special districts that you serve on, and so I really do applaud county staff and the auditor, treasurer, tax collector, controller, whatever other departments, Rita, that you run. I really appreciate your staff for volunteering their time and you for volunteering your time as well, and also our county counsel's office and other local government attorneys. So let's give them a round of applause, first of all, to thank them for volunteering for this. Like I said, this is the fifth time that they've done this, and I know that there will be more in the future. Many of you, as indicated by the show of hands, are back for your second, third, fourth, maybe fifth time. And each time what we try to do is adjust the curriculum to the needs and questions of audience members. So I hope you will continue to find it interesting and new. Take advantage of the experts that are here this evening. They have a lot of information to share with you. They are here to help you. We want to help see your special districts function as well as they can, because at the end of the day, you're all serving the same constituents that we serve, and it helps to make our jobs easier as well here at the county. So I welcome you. I hope your dinner's good. I'm sure it will be. There's coffee in the back. I see that, and I know your presentation will be excellent. So I hope you have a wonderful night tonight, and as always, if you ever need anything from the county, we're here to help. So thank you very much. Enjoy your evening.
Well, thank you again all for coming. My name is Marit Erickson. I'm with County Council, and I will be making a couple of presentations tonight, but I'm also sort of the housekeeping person, the MC, if you will. Again, Supervisor Vanderpool mentioned the food. Be sure you get your meal. They're in the back. There's plenty to choose from. Also, there are booklets which have the PowerPoint presentations in them and room for notes. There's also a certificate that you attended. We are going to be taking several breaks, but absolutely feel free to get up and stretch your legs or get some more water, use the restroom, which are just outside here or either door, and just down a little bit this way and on your left. Please turn off your cell phones or put them on vibrate. And I think that's all I have to say for now until I'm back. We have Paul Sampietro first off.
Good evening. I work in the auditor's office under Rita. I'm over the claims division. So if you are a district that has several accounts with us, we call those maybe a bookkeeping district, and so you'll be dealing with Janet Newman. That may ring a bell. Otherwise, in our office, if you just kind of have us on a less intensive basis, you will be dealing with Rhonda Cope. So, I supervise that division, and so we're responsible for all the checks going out of the county, and for reviewing all the payments, including all of the special districts. And so tonight, I thought we could just take a few moments and look at the district budgets and payment vouchers. Not sure, I guess. While they're figuring that out, I just wanted to say also that, thank you, that feel free during the presentation if you have any questions that pop up or something or an issue that you've had with any of these forms or anyone in dealing with accounts payable in our office. Feel free to ask a question, and we'll just take it from there. Okay, so I'm just going to go over a couple of the forms, like I said, that we use, and just kind of go over some of the main points that we find issues with. And if, like I said, if you have anything that you want to add or ask, feel free. So I'm going to talk about some of our forms and the reports that we send out monthly, preparing a budget at the beginning or before the beginning of the fiscal year, amending a budget, preparing payment vouchers, and then maintaining adequate cash. And we can talk about also. Okay. And so if you, we'll talk about also the difference between cash and budget, because sometimes those things can get confused. Okay, so the PVQ, you'll notice also in this first tab on the book is district budgets and payment vouchers. At the end of all the PowerPoint slides, we provided you with those forms, the PVQ, the budget, and the, well, it's in order. It's actually the order to disperse funds, where all of your board members sign, the budget, and then the PVQ. And so it might be helpful during the presentation to kind of go back and look at that form if it's hard to see up here on the screen. Okay, so starting with the PVQ. This is our standard form we use, and many of you, if you've been doing this for any amount of time, are familiar with this form. This is the form we use for each payment so that we can get the basic information that we need from you to make sure that the payment is applied correctly to the correct account, and that it is and that it has the proper authority. One thing that I wanted to reiterate on these payments is that you'll see there it has the fund line and the agency and the organization. Two that I wanted to draw your attention to. This is the wrong slide. The circled ones there, I don't know if you can see them, but there's the object code. That's our expense line. Okay, and that's primarily what you're going to be paying out. That's when we talk about the account that you're paying out, it's that line, that line there, right in the center of the page. Then the next one, the one further over, is the balance sheet account. And sometimes if you have a loan or something outstanding like that, you might be paying out of a balance sheet account, right? Something that you've set aside to make periodic payments on. One thing to note on this that sometimes is an issue that comes up in our office is the vendor code. We'll send them out to you, your list of vendors. We maintain a set of vendors for each district, and so make sure that when you're telling us who to pay, you use the correct vendor code. And if you need that list, see me after, or you can always email Rhonda. I'm going to leave some business cards here too. And you can email Rhonda or Janet, or just call the main line, and we'll provide that information for you. So just be careful about entering the right vendor information. Okay, so the order to disperse is fairly straightforward. This is you as the board. If you're a board member, how many of you want to kind of differentiate? How many of you are board members? Okay. Well, more than half. And then how many of you are either also or only like a manager or secretary, one paying the bills? Oh, okay. All right. So this is kind of where you two meet. The order to disperse is where we want, as the auditor, we have a fiduciary responsibility to make sure that the assets we hold in trust are safeguarded. And so when a manager or secretary who's been delegated that authority sometimes or sometimes not to make these payments to these vendors, this is where we want this sheet because we want to see that the board has authorized these transactions and that the manager or the secretary isn't acting unilaterally, right? So, and sometimes I know that it's a small district and sometimes that can be an issue, but for the most part, this process has been running very smoothly, and we're very pleased with it, and hope that you guys are too. So that kind of speaks for itself. We're just looking for the board's authorization of these transactions. Yes, sir.
So all these processes for the county to disperse the funds, right?
Correct.
Those districts who have revenue, they disperse themselves. They don't have to come to you with their vendor list, right?
Are you saying, if I'm hearing you correctly, you're saying that do certain districts if your district is not already involved in doing business with us in that way of doing all the disbursements, because some districts have a different relationship with us. Is that what you're saying? In your district, you do your own stuff and you're not using this. Is that what you're saying? No, the vendor list is something that through payments over time we've accumulated that we can send to you if you aren't sure which number, our internal number, to use for the vendor. Is that clear? It's a list that we have from doing business with you that we can send to you if it's something that's unclear to you. So it's not something you have to necessarily provide to us, no. Okay. Thank you. Good question. Okay, so the next one I want to talk to you about is the budget and preparing a budget. Each year, I think around May, we usually send these out, and and the thing about the budget, if you've worked in private industry, you know, you have your budget and you pay your bills, and you just kind of have to watch those things. In government, it's different. We put the budget into the journal, and it has its own journal, the budget journal. And so when you give us your budget, we key that into the system. We put it in, and it has. Go ahead, ma'am. Okay. Can you hear me now? Okay, I'll be right up on this mic then. When you submit a budget each year, we put that budget into the accounting system so that it limits your spending to what you have told us you are going to spend in each category. Okay, so in a sense you are bound. The district is bound to the plan, the budget that it's made for the year. That becomes an issue during the year if you say want to spend more in services, or excuse me, if you're overspending your budget, then we are going to ask you to modify the budget to increase it if you have adequate cash reserves to do that. Okay, so those are kind of some of the issues that come with the budget, and I'll cover that a little more later. The reports that we send out each month to the districts, there are several there. Some of the reports are available online. How many of you of the districts have internet access? Most? Some? How many? Okay, how many do not? Or how many don't have aren't able to get the reports online? Okay, a couple. So regardless, we send out all. There should only be 7. That top one, you don't need to worry about that top one. I don't know how that got on there. We send out all 7 of those reports each month, unless, of course, some of the districts have said, okay, we can go ourselves and get the ones that are online. The ones that are online are those 3 that are second to the bottom. So the BA 103, the 203, and the A 614. So that's the trial balance, which is your balance sheet accounts and where you're at positionally, and the revenues and expenses. Those we put online each month. Now, like I said, but the rest of them we will send out to you, or if you haven't told us, we'll send all of those to you monthly. One thing I wanted to note here that sometimes becomes an issue is when you have an external auditor that comes out and you're in the process of an audit, these reports become very important. And sometimes we'll get the phone call from the district that they need these reports. So it's a good idea to keep all the reports that we send to you so that the detail is there and available for the auditor, and you don't have to wait on us to get another copy. Yes, sir.
I think at this point it might be important to make a distinction between those districts that have funds on deposit with the county and run all this through the county, and those districts that do not.
Sure. How many of you are running your accounts payable through the county? Okay, good number. And so the rest of you aren't. Okay. Yeah. So of course, this is much more applicable to you, those that are running your payables through the county. Okay. One of the reports that I wanted to highlight, because it does become an issue after the year closes, is the summary trial balance. And it's hard to see, I know, but on the far right there, that's the ending cash balance. Now, if you've been doing it for any number of years, you're aware that July through about January, when we've closed the books, but we have not yet completed the audit and closed in the revenues and expenses into the balance, that number is not accurate. What needs to be done is you have to take June 30th's ending cash balance and add it to the July's cash balance, to the August, September, October, November, December, January, until all of the transactions close in and we process our year-end process. And if you have more questions, like I said, you can always call the office. But that becomes an issue sometimes. But once you've done it for a year, most districts seem to kind of catch on to how that report works. Okay, covered some of this, but just want to kind of highlight here that fourth point: ensure to balance the budget form on the last page, entering any residual balance as a contingency. We asked you to do that. It makes things easier to when you submit your budget. If you have $100,000 in revenues and $80,000 in expenses, and you have $100,000 in cash. Well, that's $100,000 in cash plus $100,000 in revenue is going to be $200,000 minus the $80,000 in expenses. So you're going to have another $120,000 left. So we ask you to put that in contingency to bring that to zero, so that we can see that you've accounted for everything. It's kind of a check for us to make sure that everything's been accounted for. So. And we send out the instructions with the budget and all these forms. And like I said, if at any time anything's unclear to you, always feel free to call our office, and we'll be more than happy to help you, walk you through it. Amending a budget, this comes into play sometimes, like I said, at the end of the fiscal year when districts may have run out of budget. And what we will, for those districts that are processing the payables through the county, we will limit the payments going out. So if you are out of budget, we'll be giving you a phone call. So I would encourage you to watch your budget and to see if, especially towards those last few months of the fiscal year, to make sure that you have adequate budget to cover the remaining expenses for the year. Okay. And I kind of went over pairing payment vouchers. This is nothing new, is our deadline to make sure that you get a payment. So, for instance, if you want payments to go out next week, you'll need to get them to our office by this Friday at 5 p.m. That's That's our deadline so that we can have checks ready for you the following Thursday. We've had that for a long time, so like I said, those of you who've been doing business with us are aware of that. Just want a reminder. Maintaining adequate cash. This sometimes can become an issue for districts. It's kind of goes without saying, but it's similar to the budget in that if you don't have adequate budget, we will hold the payments until you can increase the budget. And this, because like I said, the manager may say, "Well, these are payments; these are authorized payments," but the board designated this much to spend in the year, so we're going to ask that same level of authority, the board, to modify the budget or increase the budget. The same is true with the cash. If your cash is at a level where the payments going out are going to bring the cash into a negative position, we'll also be contacting your district to bring in more cash or hold the payments until we do. Like a bank, we're not going to issue payments without cash. Okay, so that's really it. Just kind of review, like I said, the forms. Those are the main forms. The reports and budget. If you have any questions, like I said, you can call our office. You can call Rhonda or Janet in our office. Some of you probably already have a relationship with them, and that's it. Thank you. Yes, sir. For all the districts combined, I couldn't tell you. Yeah, it's probably, I know it's in probably because some of the districts are very large. Like if you add in the water districts, it could be in like hundreds of millions. Yeah, 500 million. Man, that might be high. I couldn't tell you right off the bat, but yeah, in the hundreds of millions probably. Now the districts that we do a regular business with, it's much smaller than that. Maybe in a couple $2 million worth of. If you want to follow up, I can get you the exact number. If you, well, like I said, I'm not sure, but right in the hundreds of millions. Yeah, maybe. Okay, thank you. So, next we have Emily from our elections office.
Sorry about that. Good evening. My name is Emily Oliveira, and I'm the Deputy Election Supervisor with the Tulare County Elections Office. And tonight I'm going to be presenting on special districts filing for election and also filling a vacancy. For your convenience, I've also included appendix pages at the back of my presentation. And anytime I'm referencing a form, I'll go ahead and include that reference page for you. First up, we have the requirements of the district. On April 1st, the Elections Office will send out a district packet to each special district office. The packet will include an incumbent verification form, a resolution, candidate filing notice, and a district map verification. The district packet is sent to your offices early so that you have enough time and an opportunity to plan your board meeting so that you can have the resolution passed and returned to our office by the requested date of July 1st. The incumbent verification form, the elections office will supply a list of incumbents that we have on file as of that time. We'll also include an appointed board member director information sheet, which is available on the appendix page 3. This sheet will be used to, once you receive our list, you'll verify the accuracy of our list. If for some reason you had an appointment during the term of the office or something's not correct on our appointment list, you'll use that form to let us know that our information is incorrect. Making sure that we have the correct incumbent on file will help us to make sure that the deadlines close appropriately or an extension period will apply if necessary. As I mentioned, return all the completed forms with your resolution by July 1st. The resolution is pretty much straightforward. A sample is provided on Appendix 4 through 6. Adopting the resolution allows you to request and consents to the consolidation of your election with all the other elections that might be occurring during that time frame. And it sets forth the specifications of the election order to be had for that election. Another form is the candidate filing notice. This is an informational form that we'll go ahead and supply to you. It has all of the important dates for your officers to go ahead and file, nomination period, declaration period. It has instructions on how to get to our office. It also includes a reminder that all candidates need to file a FPPC Form 700, Statement of Economic Interest. Having a completed Form 700 at the time of filing will help your candidates have a smoother and less condensed time and experience filing their paperwork in our office. Form 700s are available at the FPPC website. That's the Fair Political Practices Commission. And that website, available on the appendix page 9, is www.fppc.ca.gov. The Form 700, along with all of the other FPPC forms, are also available and can be obtained from the elections office. The district map verification will be included. New this year, we're going to actually supply a map to you in your district packet and ask you to confirm the boundaries of your district as we have it on file. In years past, we've asked that you please supply the district map to us. But from experience and learning from other processes, we feel that most of the time the map isn't always supplied, and so we're hoping that by supplying the map to you and asking for verification that we can confirm your boundaries. This will help the elections office ensure that all of the voters entitled to vote in your district will actually receive a ballot. And with that, this concludes the filing, special districts filing for election portion. Up next, I have the filling of vacancy portion. This section contains many references to government code. So on the page 9 of the appendix, I've supplied a website where you can go and look up the actual government code if you feel so inclined. We'll go ahead and cover the different types of districts as well as the 2 types of procedures for filing for a vacancy. One scenario is no one runs for the office when it's open for nomination, and the other is when a vacancy occurs during the term of the office. We'll also cover the 60-30 rule. The first type of district is an appointed district. Appointed districts, as it implies, are always appointed by the Board of Supervisors or the appointing authority. which in some cases might be like a city council or something along those lines. But those are appointed districts. And elected districts have their board members elected either by a voter district or a landowner district. And how you fill a vacancy will depend on which type of special district that you are. If you're an appointed district, then the procedures are really quite simple. You contact your appointing authority, which is usually the Board of Supervisors, and you advise the Board of Supervisors of the resignation effective date, and then you wait for the appointing authority to take action, and that's all you have to do. As an appointed district, if your appointing authority doesn't take action and it's not the Board of Supervisors, there is a provision in Government Code 1779 that allows for the Board of Supervisors to make an appointment to a vacancy where an appointing authority failed to take action within 90 days. For the elected district, there's two types of vacancies that can become available. In the first situation, no one runs for the position when the office is open for election. And the other is when the position becomes vacant during the term of the office. The first responsibility for your district is going to be to determine which type of vacancy that you have. In the first vacancy situation, the filing period closes and the election office notifies the Board of Supervisors that nobody filed. The Board of Supervisors then may appoint a qualified person from that district to fill that board seat. And then please note that the Board of Supervisors has a deadline to appoint someone to the vacant seat. They have to make that appointment during their last board meeting before the start of the term, and so the start of the term is the first Friday in December. So usually the Board of Supervisors has to complete that appointment by their last board meeting in November. When no one runs for the office, if the Board of Supervisors fail to act, the position is deemed vacant as of the first Friday of December, and that would then follow the next form of vacancy when there's a vacancy during the term. When the vacancy during a term occurs, the Government Code 1780 will most likely apply to most special districts. Government Code 1780 is quite long, so I'll spend the next couple of slides trying to summarize that for you. And if you ever wish to reference the Government Code 1780 on your own, again, there's that website on appendix page 9. Government Code 1780 essentially says that the district has 60 days to appoint somebody to a vacancy or call for an election. If the district fails to act within that 60-day time frame, the Board of Supervisors has the next 30 days to order the district to call an election or to fill the vacancy themselves. And if no action is taken within that initial 90 days by either the Board of Supervisors or the Board of the Special District, then the Board of Supervisors must make the Special District call for an election to fill that vacancy. So when does the clock start for your 90 days? The cumulative 90 days starts when one of two conditions are met. The first one is when the district board is notified of the vacancy. And the second condition is when the effective date of the vacancy occurs. And you determine which one applies based on whichever is later. As an example, if an incumbent passes away, say on a Monday, and the family doesn't notify the special district office until Thursday, then the district has from that Thursday 60 days to go ahead and either make an appointment or call for an election. But if a board member submits a 1-month notice on the first of the month, indicating their effective resignation date as the 30th of the month, then the 90 days starts on the 30th day of the month, which is the effective day of the vacancy. The second example leads us to Government Code 1750, which outlines the proper way to submit a resignation. First of all, a resignation has to be in writing, and it has to be submitted to the clerk of the Board of the Supervisors or the corresponding appointing body's representative. It also must list the effective date, and in some cases, it may be deferred for up to 60 days. Events causing a vacancy are listed in Government Code Section 1770. It's an extremely long list, but the most common causes of vacancy are death, resignation, and moving outside of the district which you are serving. Continuing on with the steps outlined in Government Code 1780, after the clock starts counting the 90 days, the special district must notify the elections official within 15 days after they were notified that an election has occurred, and they also must send a notice to the Board of Supervisors. This will allow us to keep an eye on the vacancy and make sure that it's appointed or filled within the 60-day time period, and make sure that we don't have to take action within the following 30 days. Excuse me. Once the special district has notified the elections office and Board of Supervisors, their 60 days continues, and the district will then have to appoint somebody, or they can call for the election to occur. If the district board decides to make an appointment, then you must post a notice in 3 conspicuous locations throughout your district indicating that you have a vacancy before you can appoint a board member. If you fail to comply with that notice posting, then any appointment that you wish to make cannot happen because you failed to meet the requirements of posting. If after posting your public notice you find that you have a plethora of interested candidates for the appointment, then the Brown Act has a clause which allows you to use an ad hoc committee composed solely of less than a quorum of board members to discuss applicants and then recommend the finalists to your full board to take a vote on. That one. Once the district board has narrowed down a candidate to appoint to the office, the district must still do the following. They must contact the elections office to make sure that the applicant considered for appointment is a registered voter and residing in the district. They must also take the action to appoint that member after they've confirmed their eligibility, and then they must notify the elections office within 15 days after the appointment, and you'll also want to go ahead and send a notice, a copy of that notification to the Board of Supervisors. If the district's 60 days have passed and no action was taken, then the board does then the appointing authority has 30 days to appoint someone or order to the district to call an election. At that point in time, you'll want to make sure that you notify the elections office as well as the Board of Supervisors that you have passed your 60-day mark and that you're requesting the Board of Supervisors to take action. Because if we don't receive that appointment of the notice of appointment for your candidate, then we'll be calling your district and asking for that, and then at that point in time you'll have to go ahead and notify us that you are relying on the Board of Supervisors to take that action. So and it helps the board to realize that they have to take action as well. If for whatever reason both the district and the appointing authority are unable to take action within the allotted 90 days, then the district has no other option and they must call an election to fill the vacancy. If you have appointed a candidate to fulfill a vacancy, how long does the appointee hold office? If the vacancy occurs within the first half of the term and at least 130 days before the next district election, then the position is held until the next general election for that office, not to exceed 2 years. At that midterm point for the short-term office, the appointed incumbent may in fact run for that office again, and the winner of that election will then take the remaining of that term until the next scheduled election for that office. But if the vacancy occurs within the second half of the original office holder's term, then the appointed candidate can then go ahead and fulfill the remainder of that term without needing to have a short-term election halfway through. There's a special rule for a no quorum. If you have a number of resignations or vacancies on your board and you no longer have a quorum, then the Board of Supervising or corresponding appointing authority will go ahead and appoint members to fill those vacancies until there is enough members on the board to make a quorum, and then the regular rules for vacancy will go ahead and apply. The Board of Supervisor or other appointing authority must appoint or elect, will limit the number of appointees to enough members to fill the quorum. And with that, that is all that I have for special districts filing and how to fill a vacancy. We've also included the Tulare County Registrar of Voters webpage because it has a lot of guides and reference books to help you with how to fill a vacancy and other common procedures that need help with. Thank you.
Okay, now I will be presenting on the Brown Act, which is the open meetings law. It's a sunshine law about public access to government. Again, my name is Marit Erickson. I'm with County Council. I've been with County Council for a couple of years. I've been an attorney for about 10 years. And this is one of the areas that I am assigned to at the County Council's office, so I'm sort of the second in command when it comes to the Brown Act. So I'm pretty well versed, and if you have any questions at the end or during, just feel free to raise your hand. Can everybody hear me okay? You can hear me back there? Okay. So first of all, what is it? As I said, it's about open meetings. It's about giving notice to the public about what the board is doing and making sure that the public is able to participate in government. And why is it important? It's because the government is supposed to be representing the people, elected by the people. And the public needs to be able to observe, monitor, and evaluate its elected representatives. And so, as a result of concerns from the public of of backroom dealings and such, over time this has evolved to protect the public's right to know what their government is doing. And so, the question obviously next is, does the Brown Act apply to you? And it applies to all local government agencies. And I told you in the PowerPoint presentation, which you have, that is defined as the county, city, whether general law or chartered, city and county, town, school district, municipal corporation, district, political subdivision, or any board, commission, or agency thereof, or other local public agency. So in other words, most likely, yes, the Brown Act does apply to you. And so the governing bodies of all of the above, all the boards, committees, and bodies created by federal and state law. Yes, in the back. It depends if that's a nonprofit organization. There are very select corporations that the Brown Act applies to. Most of the time we're talking about government agencies here, so I'm not really familiar with when it applies to nonprofit corporations. I'm sorry, I can't hear. Do you have the microphones back? Yeah.
I believe it's a nonprofit football organization.
Unless it's somehow has to do with the government or a local agency, then it probably is a private nonprofit. But I'm sorry, I don't really know about that. I do reference that there's a small section of corporations where it does apply, and I'm not sure if I have an example in here or the details of it. I can, if you give me your information at the end, I can look into it and get back to you on that. Yes. A foundation that has to do with College of Sequoia. Not necessarily, because that might be a foundation that it's not put together by the governing board of the college or the hospital district. And so if it's like a volunteer or a separate foundation that raises money for the hospital but isn't controlled by the hospital, it would probably be a different situation. So for most of my focus is on government agencies. Did you have anything to add? If it had the same board, it would have its own complications. Just a second, because obviously that board is covered by the Brown Act, and then if they're all meeting as a separate board somewhere else, then they're going to run into issues as the other board, but not so much because they're on a foundation board. Yes, we had another question? Yes. Water districts, yes, as opposed to like just private, like a mutual water company or. I should have been prepared for that question, and I am not. I apologize. Let me see if I have the. There, as I said, there is a section where the corporation acts like a public agency, and so I think it might apply there, but just give me a moment here and see if I have it in my reference materials even. Since I'm guessing that that's a question that a lot of people have. And I apologize again for. Okay, so the governing body of a private entity is considered a legislative body if it was either created by a legislative body to exercise properly delegated authority. So as I said, if the board of the hospital district created this other body, or if it receives funds from the local agency and its governing body includes a member of the legislative body of the local agency. So I'm thinking that no, because it's not been created by a legislative body. unless that's not the case and there's a special case for it. But if you wouldn't mind giving me your contact information at the end, I just want to double check that I'm giving the right answer. Okay, so let's see. Again, as Emily mentioned, typically you would have the Brown Act applying to subcommittees of, or joint subcommittees, but as long as the subcommittee is comprised of less than a quorum of the body above it, and it's an ad hoc body, the Brown Act doesn't apply. So as she was saying, in the situation where you've received a lot of applications for an appointment and the board creates an ad hoc subcommittee to just review the applications and come up with a recommendation, that's not going to be a Brown Act body. If, however, the board created a standing subcommittee that always did a certain thing and advised the board about it, then it would be covered by the Brown Act. Any questions about that? Yes. Not necessarily. What happens is that beforehand, usually there's a meeting with the chairman of the board and maybe the CAO and county council to discuss what is actually already on the agenda. But it's not the full board. If it was the full board or a quorum of the board, it would be a problem. It's not, because it's not a meeting of the board. It is, but because there isn't a quorum, it's okay. Or really, and it's not a majority either. Yeah. So then I have my little shark here who's going to bite you if you don't follow the Brown Act. I don't like clip art too much, but I enjoy those kind of things. So the compliance with the Brown Act can be enforced by a civil lawsuit. A court can declare board actions void if they were not in compliance with the Brown Act. An agency can be liable for significant costs and attorney's fees, and there can be an issue with a civil rights issue. So you always want to be considerate of that as well. There are also criminal penalties, and a violation may be a misdemeanor if there's wrongful intent. So if you're intentionally hiding something from the public, that could be a misdemeanor. So again, the Brown Act has to do with open meetings, public access, and public participation. They want no secret backroom deals. And the Brown Act establishes the rules and procedures to make sure that the decision-making bodies are, accessible, open to the public, and they're acting in the public's eye. It also provides the means and procedures for the public to be informed about what's going to happen, who's making what decision on the board, who's voting for what, etc. Okay, so what is a meeting? And according to the statute, it's any congregation of a majority of the members of the legislative body, whether they are meeting to hear, discuss, deliberate, or take action on any item within their subject matter jurisdiction. So it doesn't matter if there's a majority of the board, say it's a water board, and or a water district, and the board of the water district, a majority of them get together, and they're not going to take any action. They're not even going to necessarily talk about anything, but they're going to hear from one person present about some issue that's of concern to them. That would be a Brown Act meeting. even though they don't talk about it, even though they don't take any action, they're still hearing it, and the public wasn't noticed and told that they could be there to hear the same information that the board is getting. So it's pretty strict in that regard. It's very concerned with the public knowing what the board knows, hearing what the board hears, hearing what the board has to say, participating and giving their 2 cents about what the board is about to do. So again, and it has to do with this, it matters what they're talking about. If it's a majority of this same water district board, they're talking about Disneyland, it's fine. But be careful, because somebody sees that board together at lunch, they don't know you're talking about Disneyland, they might start raising a question about whether you accidentally talked about water, etc. Okay, so exceptions to the meeting. Oh, yes, in the back. Can you get him the...
Have we violated the Brown Act?
Probably not, because that's not exactly the subject matter jurisdiction. I mean, if it's a pipe that is a part of the water system that the water district, I mean, you know, there are exceptions for emergencies and stuff, but probably you want to have one of those members step back and not be there. Yeah, and you know, even we on our team, we had a training at the emergency services a while back, and we said, well, if there's a huge emergency, doesn't every member of the board come down here and want to know what's going on? And they said, no, they will actually find out who's going to be here and make sure that they're not all here at the same time. So it sometimes can almost defy common sense or logic, but it's because it's such a slippery slope of not including the public, you have to err on the side of caution. So some of the exceptions are for conferences and trainings and workshops, community forums, attending other meetings of other government bodies. Again, you probably don't want to be participating too much. You don't want to give the appearance also of violating the Brown Act. Social or ceremonial occasions. Staff can meet individually with a majority of the board members, but one at a time. But they can't then you can't discuss what the other board member told that staff person. So that would be considered a serial meeting, which is not acceptable. So you can't have one staff member go, okay, what do you think? Okay, John thinks this, what do you think? Okay, John and Liz think this, what do you think? Okay, John and Joe think this, Liz, what do you think? And kind of get a consensus that way, because that still violates the Brown Act, even though they didn't all meet together. So again, serial meetings are not okay. That's a series of communications between individuals affecting a discussion, like polling for consensus. And I say on here, beware of emails, because when you start hitting reply all to emails, then you start having a discussion that's not involving the public, and you can be violating the Brown Act there. Okay, so rules for the meetings that are for Brown Act bodies. They must be noticed in advance. The meetings must only include the business described in the agenda. There's a little bit of wiggle room there for public comment. But that can't then be acted on or really discussed. The meetings have to take place within the agency's boundaries, and they have to be completely accessible by the public. So what is not an illegal meeting? Attorney-client communication, one-way communication by staff to a solitary board member, and as I said before, board members may individually confer with constituent staff, consultants, and colleagues. Just to go back here, I think I talk more about public participation and what's on the agenda, so I'll go get that again. Yes? Personnel issues are, I'm going to discuss that a little bit further on, but those are one of the times that there can be a closed session of the board. Closed sessions do have to be agendized or put on the agenda, but with limited information. So that's one of those things where there's obviously an interest in the public not knowing everything that goes on. So I will talk about that a little bit later, but there are situations when the board can meet in a closed session not open to the public to discuss certain specific things, and I will talk more about that. Okay, so the notice, and I'm sorry that I'm kind of reading some of these slides. I want to be precise, so I fill in where I can, but with some of these things I want to make sure that I'm telling you exactly right and I'm not missing anything. So you need to post the agenda 72 hours in advance. It needs to be in an accessible location. It needs to be mailed to the persons that have requested mailed notice. If you maintain a website, you need to post it on your website. Special meetings may be called by posting an agenda at least 24 hours before the meeting. And written notice to the board and some media is required. Okay, so the agenda itself has to tell the time and the place of the meeting, and most governing bodies have a regular time and place set. It has to have a brief but clear description of every item that's going to be discussed. Oh, yes, thank you. Thank you so much. Including the closed session items. So as I was saying, you still have to mention that you're going to go into closed session about a particular matter, but that can even be limited how much information you give out there. It must include a time for general public comment about things that are not on the agenda. And I'll talk, I think, a little bit more about this later, but also every specific item, ultimately, you have to give the public a chance to talk about if they want to. Yes, in the back. Yes, so there can be emergency. I'll get that in a couple of slides, I think. Probably not in that situation. There should probably be somebody that's already authorized to make like a quick call, or they got to put together a quick board meeting where everybody gets together. I'm sorry? Right. I'm going to get to that in just a couple of slides. If you can just give me a moment and see if I answer your question. So, as I was saying, you have to include a time for a general public comment, and then it has to have some what we call magic words somewhere on the actual agenda, letting people know that that if they need special accommodation to be able to attend the meeting, that can be provided, and who to contact to get the special accommodation, and then also how they can obtain items that were distributed to the board after the agenda packet went out. Okay, I keep skipping here. Adding items to the agenda after posting. So you can do so in certain situations. Emergencies, an urgent need to take action, or an item was continued. Hold on a second here. I want to make sure that I didn't lie to you and tell you I was going to talk about something I'm not talking about. Okay, we'll get back to that. So if you are going to have a meeting and you need to add something to the meeting agenda, you can do so if it's an emergency, if there's an urgent need to take action, or if the item was not on the agenda because it was continued from an earlier date. The most likely addition to an agenda is going to be an urgent item, and then two conditions both have to be met. You have to need to take immediate action, and no one at the county can have known about the item until after the agenda was posted. So it can't be that someone just forgot to put it on the agenda. What? Yes, except that doesn't address the, there wasn't even a meeting scheduled. And so I don't have an answer for you on the how to call an emergency meeting. So I'll have to get back to you on that, because I know that there are ways to call an emergency meeting for just those reasons that you stated. Some urgency happens and they need to call an emergency meeting to deal with it. But I'm sorry, off the top of my head, I cannot remember what they are. Okay, so I'm sorry, I'm gonna have to get back to you on that one. So again, the procedure for adding the urgent item, the board has to actually find both that the item is urgent and that nobody knew about it until after the agenda was already posted. Then they have to approve by a 2/3 vote actually adding the item to the agenda. And then once those votes have been taken, then they can actually talk about the urgency item. An alternative to adding something as an urgency item is to hold a special meeting, but that also requires 24 hours notice, so that's not quite as, that still doesn't address the absolute instant emergency situation that the gentleman in the back was talking about. But it's still, if you have 24 hours, you can schedule a special meeting. And even if you have 24 hours before the regular board meeting, you can add the special meeting, schedule it for right after the regular meeting, and then hold deal with the special meeting issues right after the regular board meeting. Sorry, I'm so hot up here. Okay, so then access to the public, access by the public to the board packet. The open session materials must be made available to the public as soon as they're available to the board. Yes? She's coming with the mic for you.
When having a special meeting, what items can and cannot be talked on a special meeting? Is this, you cannot talk about like for a water board, delinquent accounts. What would an item be on the special meeting agenda?
That is another excellent question that I did not anticipate, and I do not know the answer to. I'm sorry. I feel very embarrassed right now. Luckily, we have all of your contact information, so if I need to send out a little memo answering all these questions, I can. Because I don't know... I don't know that it's particularly limited, except that I don't think you can have a closed session in special meeting, but I will need to get back on that. Do you know? No? Something. Okay. Okay. One second. Okay. So again, most meetings have to be held within the agency's jurisdiction. There are certain exceptions, like sometimes the board goes to Washington, D.C., the Board of Supervisors, or if you were going to inspect real property. Now, those are exceptions to having to meet within the jurisdiction, but they are not exceptions to the Brown Act. So those meetings are still agendized, still open to the public, et cetera, et cetera. So really, even if the whole board is going to inspect a building that they're thinking about buying, the public has a right to go and be there with them. So this probably should be obvious, but the board can't meet in any facility that prohibits the admittance of any person on the basis of race, national origin, ethnic group identification, religion, etc. You can't meet in a place where certain members of the public are not allowed to go. You can't meet in a place where people who need disabled access cannot get access. Or where the public has to make a purchase in order to stay there. So if you were to meet at a restaurant, you'd have to make sure that the public could be there without having to buy dinner or even a coffee. So as far as long distance participation, some people have asked about calling into meetings, etc. Teleconferencing can be authorized if it's prearranged, but the weird thing about it is that the public has to be able to also be at the place where the person is calling in from. So you can't just call in from your car and attend the meeting. The public has to be able to be at the same place as the person calling in. So, I mean, I guess if you were going to prearrange it and you were going to be just in a remote location in the county or something, and then maybe other people that wanted to participate in the meeting but couldn't because they also are in a remote location in the county could then be there too and participate through the telephone. But it's not as easy as just arranging, like I'm not going to be there, so I'm going to call in from my cell phone wherever I happen to be at the time. As I said. So. Okay. Again, they have to be open to the public. The locations have to be on the agenda. Agenda must be posted at each location. So, you know, like I'm going to be calling in from wherever, you have to have known ahead of time that was going to be where you were calling in from and posted the agenda there too. So it's pretty cumbersome. It's not like an easy, just quick fix. If you can't make it to the meeting, call in kind of thing. Okay, so again, all meetings must be open to the public unless the closed session is authorized, and I will talk a little bit more about closed session. Do we need a break, or can we power through to the end of my presentation? Looking okay? Okay. All members of the public must be allowed to attend. You may not require members of the public to identify themselves. You can ask, but you can't require it. And a sign-in sheet must state that signing in is voluntary. You must allow recording. You can have disruptive attendees removed. There are no secret ballots allowed. And you must publicly report out formal votes in open session. And by that I mean when formal votes happen in closed session, you have to come out and report what the vote was and who voted for and against. Yes. Yes. Well, not necessarily. First of all, going into closed session to discuss financial issues may or may not be a violation already. We'll get to more on the closed session in a minute. But if they're legitimately in closed session and they're discussing something and they don't actually take a formal vote, like, okay, we're going to have a vote. First, you know, someone will make the motion, someone will second it. We're going to vote on this particular action, as opposed to saying, okay, like, let's have the staff look into it more, or, yeah, I think that's a good idea. You guys can go ahead and authorize that. If there's no formal vote taken or required, then there may not be a reporting out. Yes. honestly, it depends. It depends what was on the agenda, the open session agenda about the closed session, whether they were legitimately going into closed session on a particular issue authorized by the Brown Act to be handled in closed session, and then whether they only discussed what they were authorized to discuss in the closed session, and then whether they needed to take a formal vote and took the vote and then did or didn't announce out. For example, with the Board of Supervisors, we have a lot of checks and balances, safeguards, forms that we all fill out before we even get it on the closed session agenda. There's a form that is for Kathleen Bales-Lang to be able to look at, know whether she's going to make a report out. She'll often announce, I don't anticipate a report out, or I do anticipate a report out. And that's kind of based on what she knows about what's on the agenda for the closed session. So without knowing quite a bit more detail about the situations you're referring to, I can't know. I will discuss a little bit more about what is authorized to be discussed in closed session. And so if it's just like, oh, we're going to go talk about finance, yeah. Again, and I don't know if everybody knows what you're talking about, and I don't, like a specific situation. But it depends, again, on the circumstances of why they're discussing it. Is a litigation that they're discussing? Are they discussing an employee matter? It totally depends on whether they're allowed to go into closed session at all. Whether they've properly agendized it in the open session. So that, without knowing the specifics, and I know you probably can't go into it and it wouldn't be appropriate, but I will actually address closed session in a little bit more detail. There are specific circumstances. So if you feel that it doesn't fall within those circumstances, then of course that would be a problem. So I'm not telling you it's not. I'm not telling you that you're not telling me about a Brown Act violation. I'm just telling you that I can't know just based on the facts that you've told me so far. Okay, I mentioned this earlier. You must give the public the opportunity to comment on each agenda item. So some boards and commissions, including the Board of Supervisors, have a consent calendar where they just approve a whole slew of agenda items in one fell swoop. And that's fine as long as they've given the public the opportunity to pull off any particular agenda item that they want to address specifically. And they do that. Again, you may adopt reasonable limitations on how long a person can speak at public comment. The Board of Supervisors has a 3-minute limit. If there are comments made by the public about things that are not on the agenda, the board may briefly respond. They may ask questions for clarifications and make brief announcements. If something comes up at public comment that is a real concern for the board, but it's not on the agenda, really the only alternative is to then say, okay, let's put this on the agenda for our next meeting, and we'll actually discuss it then. And that way everybody else that's in the public will have a chance to actually know that that's going to be discussed by the board. Again, the board can make brief announcements. They can provide brief reports on their activities, which if you attend Board of Supervisors meetings, they'll often tell you what they've been up to. They can ask staff to report back. They can refer the speaker to the staff or other resources. And as I said, they can ask for an item to be put on a future agenda. Whoop. Okay, so now we're coming to closed session. It is narrowly authorized for specific matters. Special disclosures have to be made by the board before and after holding the closed session. They cannot, in closed session, talk about things beyond the scope of what has been agendized for closed session. And I know as for the members of the public, it's sort of like what happens in the back, you don't know. So this is one of the things where you have to be trusting, for better or worse, and hope that they're all keeping each other in check. But the law is that you can't go beyond the scope of those specific agendized matters in closed session. So we have personnel matters is one reason that the board can go into closed session to consider the employment, evaluation of performance, discipline, or dismissal of a public employee, to hear complaints or charges against an employee by another person or employee. There are obvious reasons why this wouldn't be appropriate, possibly in the public forum. So this is one of those reasons why a board of a local agency is allowed to discuss it in closed session. Labor negotiations, to meet with a bargaining representative to review the negotiating position. That's acceptable. Again, this would be agendized on the open session agenda as meeting with a labor negotiator. Okay, for litigation, the board will often go into closed session to meet with their attorney about litigation, whether it's pending litigation that's already been filed, if there's a strong anticipation of litigation. Obviously, it doesn't make sense for the board of a public agency to make public what they think somebody might be suing them about or what their legal strategy is. So that's another reason why a board can go into closed session to discuss litigation. If the facts of the litigation are known to the plaintiff, there is some amount of information that needs to be placed on the open session agenda about what's going to be discussed. If the plaintiff or potential plaintiff may not know that there is even something being discussed, the board doesn't need to say anything about it. They just say that they're anticipating litigation and leave it at that. Excuse me. With regard to real property, the board can discuss with the negotiator the price and terms of the payment, but the weird thing about it is that they can't have closed session about the actual location of the property. So there's not going to be any secret that the county is possibly buying X building, or the board of this particular district is considering buying the property at this address. So, if other people are then like, oh, that's interesting, I wonder why the county wants to buy that building, or if that's a good price, et cetera, the cat's out of the bag as far as what property they're looking at, but the actual price and negotiations, that can be discussed in closed session. The other reason for closed session is the security of public facilities, to meet with law enforcement or security consultants on matters posing a threat to security of public buildings, security of public services, or the public's right of access to public services or public facilities. And that's it. So for closed session, if it doesn't fall into one of those categories, you probably shouldn't be talking about it in closed session. And if if you are, then you need to re-examine why you're doing it, and if it's really something that, first of all, obviously you don't want to be violating the law. Also, you want to examine, the spirit of the law is to let the public know what's going on and what your thoughts are on something. And it may be frustrating to have these discussions in the public eye, but you represent the public, and so that's the way the law has sort of adjusted to err on the side of caution with regard to the public having a lot of access to the thought processes of the board members and the board itself. So to address the gentleman in the back again, the idea that there's just some closed session to discuss finance in just the, just generally some financial matters, unless it's been specifically fit into one of these areas, it would be problematic. Okay. So again, the agenda has to include a brief description of the nature of the closed session. The board must disclose in open session the items that they're going back to discuss in closed session. The board must make a public report of certain actions taken in closed session. Except for those reports that they are required to make, everything that happens in closed session stays in closed session. Violations can result in a lawsuit to enforce confidentiality, etc. Any questions? All right. Now I think we do. Oh, maybe yes. Staff will be can be invited in if they are needed to inform. No, it wouldn't involve outside parties, because then you're actually getting into some kind of a due process where they're not hearing the charges against them and things like that. So no, typically the only outsiders that are going to be in a closed session will be council and maybe staff to give recommendations or to inform the board about the particular situation. But you won't have members of the public coming in and sort of giving testimony and things like that. Yes, in the back.
I have a question. Do you, on closed sessions, do you make motions to go into closed session and to come out of closed session? And
well, what normally what needs to happen is that closed session will be on the agenda. The regular old open session agenda will have a section that is for closed session. The particular items that they're going to go into closed session about will be identified on the agenda. Now, those will have limited information, so the public may or may not be able to even have a real idea of what's going to be discussed. However, the board can sort of urgently go into closed session if something comes up in the board meeting that triggers the ability to go into closed session. They can announce that they've determined that they need to go into closed session to discuss with council, et cetera. But you do want to be careful about doing that. Whenever, for example, with the Board of Supervisors, whenever we as council have identified anything in advance that may even bring up anything, we typically put a placeholder on the agenda to let the public know that this could go into closed session. And then if nothing comes up at the public hearing or whatever, we just take it off the agenda. But typically you say, we're going into closed session to discuss the agenda items listed, A, B, and C in the closed session. And then when you come out, then there will be an announcement out that they discussed X, Y, and Z matters. And then if there's a specific report required by whatever action was taken in the back, then that will be announced as well.
one other question is, what is the process when there is a complaint on a staff member, office manager, whatever? What is the process so that you do get something, you get clarification on if you have answers regarding certain questions that you need answered?
Well, that actually has a lot more to do with your policies and then employment law and things, which is not my area at all. So in terms of how you proceed with, employee discipline or complaints against board members, that's going to be more of an internal policy question. And if you are in a district that has county counsel as your attorney, that would be the labor and employment team that you'd want to talk to. Otherwise, if you don't already have policies that have been reviewed by an attorney, you might want to do that. That doesn't really have much to do with the Brown Act until you start talking about it at board meetings. Yes.
Regarding the public comments, do we have to allow public comments on each agenda item being discussed, or it can be segregated as an agenda item?
It's actually both. There has to be an agenda item specifically for just all public comment that's not having to do with anything on the agenda. And then for each individual agenda item, you have to allow the public to comment on each individual agenda item. Now, you can, as I said with the consent calendar, you can lump agenda items together and say, we're planning to approve or deny all of these all at once. If anybody here wants to discuss one of these, let us know now so we can pull it out of that bunch and we'll approve the rest, and then you can discuss and address this one specifically. So you don't have to take each item, see if anybody has comment, take another item, see if anybody has comment, because there are some that are just pretty rote agenda items that get, that they've already been determined they're going to be, that they're generally just approve or deny. And that's fine, but there has to be an opportunity for the public to say, hey, I wanted to talk about item B or whatever. Does that make sense? I would suggest that you either put it on the agenda itself, that they can ask staff to notify the board that they want to discuss a particular item, and or before you take the consent calendar, say if anybody is going to want to address one of these items specifically, then please tell us now and we'll pull that one out, just to be on the safe side, because otherwise you could have somebody waiting to talk about an item and not quite understand what the consent calendar is, and then they've waited there the whole day, it's done, and they say, wait, I was here to talk about item C. I never heard anybody talk about it. Where's my time to talk about it? Okay, I think we do need a break now. Oh, yes, one more question? Oh, thank you. Yeah, let's try 10 minutes.
Oh, you have to put in where he's calling from? And that just we were, I don't know, a bunch, yeah, but there's a bunch of little water companies, private companies, that are the only special district. We were thinking about putting like a little lunch. Yeah, can we do that? Okay, that's what I wanted to know. could have like one or two. Double check with her. She's an attorney. But that would be bad. Because I was on the water board myself. But we can make that like a special meeting. I'll double check. I didn't even think about that until she was talking about it.
That makes sense.
Yes, that does.
Of course, common sense doesn't always work with the law.
And everything works a little backwards on the mountain, so.
Which district?
Ponderosa? Yes, we're up at the top. Yes. Well, we just found five. Huh?
I just had her. Oh, I don't know. Or, yeah, no. Pirates of the Caribbean, yeah. I took the same kid when she was older though. We were at Disney World. Got on the Pirates. Yeah. I mean, it's something that, Czech had to do. Don't you That's why it's called the tower.
Okay, I propped the door open back there because it was getting warm. If you get cold, close the door. But bring the chair in first, okay?
Okay, we're going to try to get started again. If everybody would make their way back to their seats. Or just completely ignore me. That also works. No. Yeah. We're going to try to get started again. If everybody could move back to their seats. Is it on or is it rolling? Oh my goodness. And I have business cards up here if you want to ask me any follow-up questions about the presentation, anything I addressed here tonight. I'd be happy to take your emails. There may be a limit to how much I can advise you and just give you some more general information, but I will do everything that I can to assist you in pointing you in the right direction. Next, we have a last-minute substitution here. Ms. Hiley Wallace is out sick, so we have Frank Vigaria. Okay, Chief Accountant of the Treasury here to talk about remote banking.
Hi, I'm Frank Vigario, and I'm with the accountant with the Treasury. And one of the complaints we'd had received in the past is having to come all the way into Visalia to deposit the money with the Treasury. So this presentation is basically geared towards those districts that are based outside of the city of Visalia. And what we did is we set up a process about a year and a half ago to allow those districts outside of Visalia to make their deposits to the Treasury directly with a bank in that area. We have set up contracts with both Union Bank and Bank of Sierra. They're sweep accounts that you are deposited into those accounts, and then we'll sweep over into the Treasurer's main account. Okay, this process is an easy process. It's as easy as one, you make a request with the Treasury to start the service. 2, you make a deposit with your local bank. And 3, we prepare the same cash receipt form that for the auditor's office that we're currently preparing now. Okay, step 1, the districts must request the service in writing. There is a form that's in your books towards the back section. And it's a pretty simple form. It just has the contact information and some basic questions about your banking habits, about how many deposits a month you'll have and the approximate size of those deposits, and the location of the district. Once receiving that form, the Treasury will go ahead and order deposit slips and endorsement stamp that is specific to your district. So although everybody deposits in the same account, those deposit slips have an encoded number on them that tells us whose money who made that deposit. And third, there is a small $90 startup charge for those deposit slips and endorsement stamp to start the service with the banks. And those will be directly charged back to the district. Second step, upon receiving your deposit slips and endorsement stamp, you're ready to start making deposits into the bank. Which bank you use is based on location. The criteria priority basically is if you're in Visalia, you continue to deposit with the county treasury. If there is a Union Bank in your area, you will deposit with Union Bank, and if there's no Union Bank, with Bank of Sierra. The reason Union Bank is the priority bank, if at all possible, is because that is the county's main bank, and the service charges are significantly cheaper through them than with the other bank, and the process is a smoother process on our end. This map kind of shows you where the banks are located, so you get an idea where, based on where you're located, which bank you'll be using. I don't know if you can see from there, but it is also in the books. But the triangle is where the county treasurer's office is located. The circles are with Union Bank, and the stars are with Bank of Sierra. And the third and final step in the process is simply to fill out the auditor's cash receipt form. You fill that out, you email it, or you fax it to the auditor's office. They will get it input into the county's accounting system. The treasurer's office, once they get verification that the money is in the bank, which usually is the following morning because it usually goes through the nightly cycle of the bank, and then we get notification the following morning that money is in the bank, then we will finalize that receipt, and your money will be in your account at the county, where it will begin to go ahead and earn interest in our investment pool. One last comment on that: if you deposit your money the last day of the month, and you are required to show those funds in that month's monthly report, you might want to bring that money in, because if we don't get the notification until the following day, our records are going to show that the money came in. It's going to be processed as of the 1st as opposed to as of the 31st. So if it's very critical that money is shown in that specifically monthly financial statement on the county's books, then you will need to walk that deposit in. And that's basically it for the process. Last section is the goals of the service, which probably should have started the presentation. But I'll read through some of the goals. The goals when we started the service was, 1, to provide greater convenience and efficiency in the operations for the outlying areas of the county, to reduce costs associated with and time lost during travel, reduce costs and travel reimbursement claims associated with transporting deposits into Visalia, increase cash management through more frequent deposits, reduce number of vehicle miles traveled to help improve the air quality within the county. And one more that should probably be added to the list: now that the Fed is finally starting to raise interest rates, the sooner you have your money into the Treasury, the sooner you start receiving interest. And with that, I'll just open it up to questions. Yes? This past quarter was 1.3% before expenses, so it's a little bit lower than that after we reduced the Treasury costs. I don't remember exactly what the costs are right now, but we earned 1.3 this past quarter. Yes? No, we will continue to receive them, but I do want to say that during tax season, the county tax collector's office uses a lockbox, so a lot of the checks that come in, if they get our office and the tax collector's office are right next to each other. If that mailing gets mixed with theirs, it could be a couple weeks before we actually see it. The bank will return it to us. The lockbox does return it to us, but sometimes it does take a couple weeks before that deposit gets done. So especially during that time, if you use another process, but we will definitely continue to take mail-in deposits. Yes? Any other questions regarding this process or the Treasury? Go ahead. The checks? Mailing in checks? And where you have to have two signatures, it is okay to just have one line, and with two signatures, one above the other on that single line. The banks will take them that way. It might be easier to have order checks that have two lines to remind your own staff that it requires two signatures, or to remind the bank to look for two signatures. But they will take it with one. Yeah, if you can look, I'm not sure what was submitted, to be honest with you. Okay. In the back of the presentation, there is the application authorization remote for the form that needs filled out to request to get started in the process. Then there's also a user guide that we got from Union Bank on how they want their deposits prepared. The same process works for Bank of Sierra, but we got the guide provided to us from Union Bank. And for the most part, that's the same way, pretty close to the same way we like the deposits prepared for the Treasury as well. And then the following is just a kind of a recap of the process that was outlined in the PowerPoint, except in more of a procedure manual type format. Any other questions regarding the Treasurer's Office in general or this remote location deposit? All right, thank you very much.
Okay, next we have Virginia Para, Accountant Auditor, about special district audit requirements.
Good evening. My name is Virginia Para. I'm an accounting auditor with the Financial Reporting and Audits Division at the Auditor Controller's Office under RITA. Today I will be talking about special district audit requirements. Special districts are required to have annual independent audits conducted by a certified public accountant. However, they may be replaced with biannual or audits covering a 5-year period, and those would have to be approved by the Board of Supervisors. According to Government Section 26909, special districts should file the audit report to the State Controller's Office and to the County Auditor within 12 months of the years under examination. When they're submitted to the County Auditor, which that would be us, we review them and we compile what we call the Special District Monitoring Report, which gets submitted to the Board of Directors and the Grand Jury. Oh, sorry about that. Okay. The first part of my presentation is going to be on filing requirements, and I will talk about the State Controller's requirements and then our requirements. So for the State Controller's Office, your completed financial and compensation reports must be submitted within 90 days after the close of the fiscal year if you are filing via paper, or 110 days if you're filing via electronic formatting. But do note that if you're doing electronic formatting, you still have to send the cover page and the signed cover page and the census form by mail in order for your package to be considered complete. For hospital districts, there's not very many, but they do have a different filing requirement, and for hospital districts, it's 120 days after the close of their fiscal year. Please do note that biannual and 5-year reporting districts are required to file the compensation report and the completed financials on an annual basis. If you don't have any financial transactions during that year, you must still file the cover page and the general information section. And on the cover page, you would just note that there was no activity and send that in. If you have no financial transactions, but you have outstanding debt taken out in the special district's name, then you must report the debt and any debt payments on the long-term debt and revenues, expenses, and changes in fund equity form. Now, you might ask, if you're running a little behind and don't think you're going to meet these requirements, well, the State Controller's Office do not grant any extensions. So what you would be recommended to do is file via their transfer protocol, because that way you have the 110 days rather than the 90 days. If you do not file your report, you will get a letter from the state controllers saying that you're delinquent. Once you have received your written notification, you have 20 days to send in your report, and if you do not, there is a fine that's associated with that, and the fine depends on total revenue, but the fine typically ranges from $1,000 to $5,000, and if you would like the breakdown, you can reference code 53895. For the County of Tulare Auditor Controller, which that would be us, we require you to send your audit report the same 12 months after the year end of your exam of the reporting year, and you can send it to us via mail, and I have provided the address there. If you are sending it to us via mail, please address it to the Chief of Financial Reporting and Audits, so that way it gets to us, because there are several different divisions that deal with special districts. If something new that we're recently implementing, we have created an email address specifically for special districts. That email address is sdaudits@co.tulare.ca.us, and you can send your audit reports via email. Just on the subject line, we would prefer if you do the district name and then the year under examination. A lot of special districts also have their CPA firms submit their audit report to us, and that's perfectly fine as well. Any questions on filing requirements? Okay. I have a few examples, just because not all of the special districts are fiscal year end of June 30th. The first one is a straightforward one, and it's the June 30th, 2014. So if your audit report is due for the period ending June 30th of 2014, it must be submitted by June 30th of 2015, and we will document it in the Special District Monitoring Report in 2015. However, if your audit report is for the period ending December 31st of 2013, you have those 12 months to submit it, so it would be December 31st of 2014 when it's due, but it will not get documented until the Special District Monitoring Report in 2015. Okay. Example number 3, there is a typo. It should be June instead of September, and this one deals mainly for biannual audits. So if your audit reports for the 2 years ending June 30th of 2014, it must be submitted by June 30th of 2015, and it will be documented in the Special District Monitoring Report 2015. Note that in contrary to the state controllers, we do not require you to send your audit report on an annual basis if you are a biannual or a 5-year reporting district. You only have to send it in on your reporting year. Okay, so moving on to audit report format. According to California Code of Regulations 1131.4, you must have a title page, a table of contents, an opinion, basic financial statements, supplementary information, and other schedules, which would typically include your statistical tables if you have any. It should also contain your management's discussion and analysis, an independent auditor's report, and it shall state whether the financial statements are presented in accordance with generally accepted principles of accounting and the state controller's minimum audit requirements and reporting guidelines. There are 4 different types of opinions. The best one would be an unqualified opinion, so that's the one that you want to go for. And then the worst one would be a disclaimer of opinion, which is no opinion was rendered. The audit report shall contain basic financial statements that present an overall view of the district, including notes that explain some of the information. Some things that we review and go on our special district monitoring report is whether there was a net loss or a decrease in net assets. Also, if there's a going concern statement. And then lastly, we also review for excess cash and investments outside of the county treasury. And I have provided 2 tables. This first table lists the districts that are not required to have their cash and investments with the county treasury. And then on my far right, it's the government code section. So if you, just for referencing purposes. The second table is the special districts that are required to have their cash and investments with the county treasury, and as well, I've stated the government code next to each district's name. On this last slide, I have provided some resources for you. The first one is the government code section. So that one lists all the government code sections. And if you go into their webpage, like the first page will say, it has the breakdowns of all the different special districts, so it's kind of easy to navigate through it. The second one is the state controller's office as far as the templates go. And then I've also provided the instructions or the PDF to the instructions for the financial transaction report. And then lastly is the reporting forms. Towards the end of, at the end of the presentation, there is a list that lists all the special districts and whether they're required to file either annually, biannually, or every 5 years. So if you can please review that and make sure that your special district is under the correct category. If there have been changes, you can always email us at that email address that I provided, which was the SD audits, so that way we can update our files. Any questions? All right, so now Sue Copeland will be presenting allocations and direct charges. Thank you.
Is that property taxes? Is this the right?
Okay, so this is going to be the money part. How are you going to get all that money to have the audit reports done and put in the treasury? Okay. So just really briefly, before 1978, I guess I can see that one. If you special districts would say, I need $1 million, you tell the auditor, I need that $1 million, and they would tax everybody to get that money that you needed. After 1978, with the Prop 13, that no longer works anymore. So now this is the new way of how you are going to get the money from the property tax system. So some of the things that it did was revise the way that the dollar tax rate is used. If there's $1 and everybody's going to get a piece of that. So we used some of the base tax revenue from 1978, 79. This was all all done at the legislation, the state level, and so the auditor is just fulfilling the requirements from what the state had us do. Ties the allocation to your tax growth on a situs basis, and it introduced the concept of a tax rate area and an annual tax increment. And the increment is the growth from, obviously, from year to year. So what is a tax rate? And you can see as this all fills in, we can have, your district can be in different tax rate areas. So it's not just your area is that triangle right there, but you are actually involved in 4 or 5 different tax rate areas. And all of that in combination comes up with your growth. So your far right corner might be growing, but your far left corner isn't growing. So it's just a total of everything that's in your district. So those are all our tax rate areas. So you can see that your district can be in a city, it can be in the county, it can be in one school district, or it can be in another school district. And the same with the county, can have all the different districts all over. And we do have kind of a little pyramid going here where we have the parcels on top, then comes the tax rate areas, and under all those areas are all the schools, the cities, the counties, the special districts that are all part of that tax rate area. And then we have our total tax levy, which of course is the total of everything, all the assessed value in our county. The top number, the number of parcels, actually expanded. It's 174,000 this year. This was actually from last year, and we had a lot of annexations going on. A lot of subdivisions are starting to come back in, so our one parent parcel is now becoming 200, that type of thing. So we actually did expand that quite a bit. The tax rate areas are very generally the same. We have 2 more, so 1,201 of them. And then all of the districts down there, 207. So that's all of our cities and county special districts and schools. So now, how do we take all of that information? And how do you get your money? So I'm going to allocate the money. We're taking last year's allocation. We're going to add to that any jurisdictional changes that you've had. So you've either annexed something in or you've detached it. And then we're going to add your share of the assessed value growth if you're not in an RDA area. And then if there's any state shifts, which of course they'll tell us about, the state will tell us what they want us to shift, either plus or minus, and that's going to be this year's allocation. Now, that's what we would call your gross levy. So if you're familiar with the Tulare County website, there's all kinds of reports out there that we try to put all this information out there. And under the gross levy, there are a couple of them that will tell you your agency's increment, how much did your area grow, and there's also would tell you from each TRA. So you can actually, when you look at your area, which area of yours actually did all the growth for your agency. So now we have this year's allocation, and then of course next year, so we have the allocation, and then I have to add to that anything that the triple flip is the sales tax and VLF, and now we have ERAF, which is the schools, and so we're either going to add to you or subtract for you to get your actual revenue. And then this current year becomes next year's allocation. We start all over again every year. Okay. So some of the consequences of that is now you've owned your home for 30 years and you've lived in that same home. Your increase of your assessed value, so your taxes, generally can only go up 2% or less. But your neighbor who just bought his house 3 years ago bought it at market value. His value is starting at that market value. So I just kind of looked at when we're seeing 10 to 20 times, and that can be true. Right now, not so much in our area just because our growth is not as much. Our homes, the market value is not skyrocketing like it was before. But if you've been in your house 30 years and bought it for $60,000 value, your value is probably only $90,000. But your neighbor who just bought it 3 years ago bought it at about $115,000. So right off the bat, they're going to pay more taxes than you've been paying all this time for the past 30 years. So that's just kind of something when somebody says, why are they paying more taxes? Well, that's because you've lived in your house longer and have a lower base. So one other point was that when Prop 13 came in, more than 40% of that property tax relief, yes, it did help the homeowners, but a lot of it went to the corporations, businesses, and of course landlords, anybody who owns more than one home. It's no longer the local, so our local people are not saying we need this amount of money. The state is actually saying this is how much you're going to get. And they can also take it away. Allocation formulas are large variations, and they're somewhat outdated. It was all based on pre-1978 ratios. So that's what started. So whatever you asked for in 1977, 78, pretty much that's what your ratio is set on. So if you happen to have asked for a lot of taxes in that particular year, then you've got a higher ratio than another special district who really didn't. They had stuff on hand. They really didn't need anything, so they didn't ask for it. So their ratio is a whole lot smaller. And so the share of the base doesn't change. So here in 1978, we're setting these ratios. Those aren't going to change unless there's some type of annexation. So again, it's a zero-sum game. There's $1, and everybody's going to get a piece of that $1. And so if somebody gains something, somebody else is going to lose something. So it all remains the same. Okay, so then other factors, of course, would be annexations. So when cities annex the area, or a special district annexes some other area or detaches, so you can, you would either gain, you could actually gain some increment from that, so you can get some new growth. Unless you're in a redevelopment area and they're still receiving all the growth in that area. Pass-through agreements. So with the old RDAs, they're still pass-through agreements. Those are still valid, and so agencies can receive some of that money back. And the ERAF, which is the Educational Revenue Augmentation Fund, and that's where the state came in again and basically shifted some money away from special districts. And most of our special districts really do get hit quite a bit, as well as the county and the cities. And this money just shifts away. You don't see it. Okay, so now we're going to develop the formula. So the revenue collected is tabulated by the district in each of our tax rate areas. And remember, we had our frozen factors from 1978. And again, that was based on that percent of revenue back in the day, back in 1978. And now the total of all the factors in the TRA is 100%. So every TRA has a factor of 1 or 100%, and then all of those add together come up to each of the agencies. So whatever tax rate area you are in, your agency is in, add all those together, and that's how we come up with your total of your revenue. And that happens for all 200 of the agencies. And so the assessed value is, by each TRA, is distributed by the frozen factor of each TRA. So here, if we look at this one here, you can see that in 1978, the revenue, and we're just going with basically the TRA total of 1,000. So the county has the 200 or the 320, and the school district A is the 500, city 110, the memorial district is 10, the fire district is 40, and the cemetery is 20, the cemetery district. So every year, whatever is collected in that, it's all going to go by that same frozen factor percent without our shifts. So that's the basic. It starts with that right there. So for every dollar that we collect, the county will get the 32 cents, the cemetery district gets 2 cents. And that's before we've shifted anything away that the state has said, and ERAF is that biggest one. So then we would take all 2,000 of our TRAs and add up all those 32 cents for the county across the board, whatever their factor is, and it's amazing how different the frozen factors are in each of the tax rate areas. They're very similar, but they're not quite the same. And then this next one, actually at the very bottom, it's the very same tax rate area with the same percentages, but it just gives a little bit more of what basically we just talked about, is how do we, the annual tax increment from these frozen factors. So, and we call that AB 8, and that's because it came from the state as Assembly Bill number 8. So that's just a little bit more of a description down there. They're out of luck. They're out of luck. If a district is formed after I have my frozen factors here, now there is, if the cemetery district is taken over by another cemetery district, then that's okay. But if in our little scenario here, a water district wants to come in, they don't get a piece of that dollar. They're not there at the beginning. They don't get one right now. Question? Okay, so that is about 2 slides from now. So yes, there is definitely, there is, something does happen. So that's the only thing that actually will affect these. So if you can hang in there for just about 2 more slides. Okay, so let's just really quickly, the types of property that we're talking about. So the secured is the land and the improvements. The unitary is what the state is assessing. That's our all of the utilities, so Southern Cal Edison, Southern Cal Gas, Verizon, that type of thing. And those are assessed at the state level. And then our unsecured, which is not attached to the land. So businesses, equipment, and planes. So when we're talking assessed value, that's what we're talking about, is that right there. And the supplemental is the increase in your assessed value when you purchase your home. So that's also additional secured and unsecured. But the assessed value is where we're getting our ending dollar, how to distribute it. Okay, so jurisdictional changes and annexations. The 8 cities, they all have the same master agreement. And the base revenue amount stays the same with the original agency. So the growth goes to the city based on a like TRA, and a county island, there can be agreements with the city, and the base can move to the city. So it has to be a special agreement. But right now, if a city annexes from the county, basically the original base amount, so when we were talking about that first slide where I get your bottom number there, that will stay with the county, and it's only going to be the new growth would go to the city. Special districts. So they are all covered under the board resolution. Base revenue amount stays with the original agency, and all growth would go to the new agency. And if it's a new district, no part of the dollar distribution. So if we had a cemetery district that took over another cemetery district, the original cemetery district would keep the base, but the new cemetery district would get any new growth. So as there is building growth, sales that make the values go up, then the new district, the new cemetery district would receive those. Now, it depends on what type of annexation are you talking about. So if it is a district taking over the exact district, what the district does at the same time. So if it's a cemetery district taking over the duties of the cemetery district, then the original cemetery district keeps the base, and the new one will get only growth that goes along at the same percentage. Well, the original. So, are you saying that the original district is completely gone? It dissolved, and the first one takes over. So then the first one gets the increment from that point forward. They would get everything from the original district. They would get the base, and then they would get the new information or the new amount from the growth. And that's only because they took it over. I mean, the one dissolved completely and is taking and doing the same exact thing. But if it was the original district is still there and there was just whatever reason they wanted to de-annex it and the other one was going to come in, they don't get the base, they only get the growth. So if you're going to take over an area, take it over completely and dissolve the other district. Hopefully the district is dissolved. That is correct. So if they're exactly. So when you so when you come to your agreement, make sure that you bring that all out in the agreement, because we have had some of that's kind of happened, that the district is still there, but it does not still there's no other nobody else has come in and done the same duties that an ambulance district or a hospital district. So it's still there. It's still receiving that money, even though it's not doing the duties, but nobody else is taking that over. So it will still receive it. So just depends on where it's at. And also, again, if it's a brand new district coming in, they're not going to get any part of the dollar.
And make sure in your agreement that you talk about the increment and the base and say where each is to go. If you just talk about the taxes, it's just going to be the increment. So make sure you spell it out correctly in your agreement with both parts, because that's been something that's happened through the years, and some districts haven't necessarily done that, and they didn't realize they lost their money because they didn't do it right in the agreement. They had to go back and redo it. But along the way, they lost some money.
Okay. So, right. So new services, I guess, is where I was going with that one. Yeah, new services, you don't get a piece of that dollar. But taking over the old services and talking about it in your district or in your resolution when you're actually going to do it is the main thing, because you want the base. You want that chunk that was there in the first place. You want that to come to you. So here's our jurisdictional change. So in the very first two columns is our before annexation, and we have our base revenue and our frozen factor. And by the way, this is not the same TRA as that other one, because now we have different numbers here. So in the before, the city is not a piece of this. But now the city, so in the second set of column, after the annexation, the city is going to come in. But you see the base revenue didn't change. The base revenue is still staying with the county, even though their frozen factor has now changed, and the city is now going to get their 15%. But they're not going to get it from that original base. They're only going to get any new growth that happens. So that's when, in that particular case, what's covered in right now of our Board of Supervisors, when a city annexes area, they do not get the base, they only get the growth. And so now if we go to the last set of columns, now we have our new annexation with the growth. And you see there's $100 worth of growth. So now how are we going to spread that out? So you're taking the $100 by all those factors, and you'll see that the city is going to get the 15, but there's 0 there, so their total is only 15. They're not getting anything else out of that original 420. And then the county is getting only 32 instead of the 42. And then the everybody else, well, the fire district completely doesn't get anything now. They only get their base. So that's where the city came from, is it came from part from the county and part from the fire district, because they're taking over the services now. So that's showing that the base is important, but that's the agreement that the county has right now with all the cities and has had for years. So now here's our total revenue. Now we have that $100 more, and it's being distributed. Again, that's all that the city's going to get is the $15 or 15. Okay, so then we still have redevelopment. The purpose originally was to clean up the blight, help economic development, the tax distribution of that. The taxing agencies are frozen now. So whatever the base year of the redevelopment coming in, the taxing agencies are not going to be receiving any more money. They're receiving what they received at the time that redevelopment came in. There was pass-through agreements. They were negotiated pre-AB 1290, which was 1994. And then after that, it was mandated by the state, and there's certain tiers and certain amount of money that you're going to get back. But the main thing is that the redevelopment gets the growth. And then this will show that that here was our same TRA, we have our before annexation, then we have our after annexation, where you can see that the new growth, the fire district will not be receiving any new growth. The city gets the 15 and the county gets the 32. But it's in the RDA. So now that $100 worth of growth completely goes to the RDA, which is at the bottom there. So the city ends up not getting anything at all because it all goes to the RDA. And just a quick note on the RDA, and I'm not sure where I had that at, but they're still in existence. Even though they have been removed or dissolved by the governor, they're still in existence until, next slide, sorry. So the dissolution. You all possibly heard that they're gone. Well, they were dissolved, but they are not gone until they are completely paid off. So all of their debt has to be paid off. And in the case of some of them, it is going to be another 30 years. So they will still be taking the increment from city, county, special districts until that's all completed. So that's just some of this is just some of the time frame of when that all happened. But again, the main thing is that it continues until they are completely paid off. One of the things that you'll probably be noticing as a special district, if you are in a former redevelopment agency area, you are getting your pass-throughs consistently now because the auditor is paying that to you. And then you're also getting residual amounts. So as you're looking at your financials, the revenue source 4060 is the residual. And what that means is that all the money, all the increment, all the tax money that goes to the redevelopments, once they have paid all of the bills that the state has said they're allowed to pay, so basically all of their bonds, any remaining money goes back to all of those agencies that are in that tax rate area. So the school districts, the county, the city, and the special districts will receive a portion of that money back. So you might be noticing more and more, especially if you're in the Exeter area, you're getting a lot of residual because Exeter's RDA has zero due, so they don't get anything. It's all coming back to the special districts and the cities and counties. So, but again, that's going to continue until they're completely dissolved. And there's some rules on how they need to do that, and the state will be catching up to them pretty quick. So on the website, which is here, it's the CSAC website. It's an entire book on demystifying the California system. So if you ever want to have some interesting reading, it shows you how it came about and how AB8 works. So from that, I'm going to get your factor, and now I'm going to allocate the money. So after the tax collector collects all those tax bills that are out there, then everybody has their piece of the dollar. So literally all 200 agencies are getting a factor that goes out to 6 digits, and then I allocate the money. And special districts should be looking for more money this Friday. So we did a second apportionment from the 11th of December through collections from December 11th through December 31st. So any other questions on that? Really interesting. I mean, I know you'd rather just have money, but that's how it comes about, and it's really different. And the state constantly is changing things and constantly coming up with new things and new ideas. And we just interpret what they do and try and get the money out to you. But if you haven't taken a look at the county's website, go in there and take a look at, and under property tax accounting. It's under the auditor controller and then property tax accounting. And we try to put as many reports out there as we can. They give you values and taxes and revenue estimates and all of that. So, and then the second part of it that I was going to talk about is the direct charges. Now, what's in the packet is exactly what you get sent every year, and we're pretty fine-tuned to that. We don't have too many questions from our special districts who are putting special assessments or direct charges on the tax roll. So since it's all in there, you can take a look at it. Is there anything that anybody for putting a direct charge on the tax roll might have a question about. And pretty much it's on a parcel basis. You turn that information in to the auditor in August. And I think the main thing that we have is I do have Chris would be the one that everybody would have talked to the last couple of years, and he tries to send out a reminder email to everybody the end of July, beginning of August. Hey, if you haven't turned it in, get it turned in, that kind of thing. But these are the over and above the 1%. This is the special tax that can go, or excuse me, a direct charge that can go on landscape and lighting, sewer charges, delinquent sewer charges, that type of thing. So again, it's all in there. The information that's in there is from this year that's already passed. We don't have the paperwork for next year, which will be due August 10th of 16, but it'll pretty much be the same thing. There's all the forms that we ask you to fill out. Turning it in electronically is a lot cheaper. So if you haven't already done so, try and switch over to electronic filing, and it's all the information on how to do that is in there. And you can always give the office a call because Chris he'd love to walk you through it. Okay, so I don't need the other one.
Okay, we are making pretty good time here. And now I'm going to talk a little bit about Form 700. I'm going to try to sort of power through this, and we'll see how we do. Okay. So Form 700 was mentioned in an earlier presentation with regard to the candidates for vacancies. But it's something that a lot of public officials have to fill out. So I'm just going to go over sort of the point of it and what you have to disclose, kind of maybe, or how you find out what you have to disclose is really more what I'm going to talk about. I included all the information about the California Fair Political Practices Commission contact information. They are the best resource, and their website is a good way to get your questions answered when it comes to the Form 700. And we included the mission of the Fair Political Practices Commission in the slideshow because it kind of gives you an idea of what the point of the form is. They were created to promote the integrity of state and local government in California through fair, impartial interpretation and enforcement of political campaign, lobbying, and conflict of interest laws. And they regulate campaign finance and spending, lobbyist registration and reporting, post-governmental employment, mass mailings, financial conflict of interest, gifts to public officials, etc. So the three main questions that I'm going to attempt to answer are: why do public officials have to fill it out? Who has to fill it out? And how much of it do you have to fill out? Because really there is quite a bit to the form, sort of like separate parts of the form, many of which you may not even have to fill out, and then others which you may need to fill out but which won't actually apply to you. And it can be a little bit overwhelming. So first, why do you have to fill it out if you do? Because of the Political Reform Act, which the goal is to promote fairness, integrity, and impartiality. And so, as I put here, it's all about conflicts of interest and making sure that that not only sometimes either people that have conflicts or perceived conflicts, financial conflicts, etc., are either disclosing that they have those conflicts, and then at a certain threshold, they are actually forced to recuse themselves from actually participating in certain decisions. So as I said, there are two main components, disclosure and disqualification. The disclosure, the form is obviously disclosure, and you will be disclosing, including the thresholds that will mean disqualification. Who has to complete it? I put a big long list in here. It's in here. I can read it, but I'm just going to kind of try to go through it. There are some people that have to file by statute, and then there are some that have to file due to the conflict of interest code. We call them code filers. And candidates running for office, members of newly created boards and commissions that don't actually already have a conflict of interest code, and employees in newly created positions. So no public official at any level of state or local government shall make, participate in making, or in any way attempt to use his official position to influence a governmental decision in which he knows or has reason to know he has a financial interest. And then apparently I made myself a note to add references, which I did not do. So I apologize for that. The definition of a public official is basically every member of a local government agency. That's very helpful. And so I'm going to go back to statutory filers first. There's a long list of offices. It's found in the government code. It includes certain elected officials and candidates, other public officials who manage public investments. Really, the best thing is to see the list in the government code. A lot of us are code filers, which means that every agency has to come up with a conflict of interest code. And that conflict of interest code basically designates which positions have to disclose and what those positions have to disclose. And an agency is any state or local government agency. So you should have already a conflict of interest code. And as I said, the conflict of interest code will list the particular titles that are required to disclose on Form 700. And then there's a separate portion of that which is for each particular position that's listed, then what are their disclosure requirements. So statutory filers, and that's the one that I said you need to look at the government code for the complete list. Those require complete disclosure. The code filers are the ones that actually just required to disclose what their conflict of interest code says that their position has to disclose. Statutory filers are going to be disclosing investments, interest in real property, income, business positions. There are a lot of detailed rules about what has to be disclosed, and that's why, again, I initially pointed you directly to the FPPC website, because the Form 700 has instructions, and then there's actually another little booklet that it points you to help answer the questions about whether you actually have to disclose something. Once you even know that you have to disclose, for example, you have to disclose your investments. Well, then you want to understand what constitute the kind of investment that you have to disclose. And there's distinctions about whether you actually control the buying and selling of stocks, or if it's in some kind of a mutual fund where you don't, then you may not have to. And I myself, when I fill it out every time, I get very confused, and I look at the instructions ad nauseum. So I'm trying to be helpful here, but it's pretty complicated. It's hard to give a presentation that will really address all of the concerns. So, as I said, the code filers the conflict of interest code will have two parts to it: the list of jobs that have to file and what each job title the person in that job has to disclose. Each agency defines its own disclosure categories for each position based on the type and scope of work performed. So if somebody doesn't have the example that one woman in our office often gives is that a librarian who's in charge of selecting what books are purchased for the children's section of the library would not necessarily need to disclose that she has an interest in a certain property management or real estate consulting company that the county is going to use or may use to buy a land for the library, because nothing to do with her job actually has anything to do with what decision is made as to what land to purchase, etc. So that's why your job description then will determine what areas of your life you have to talk about in Form 700, basically. Is this making sense? Kind of, a little bit. Yeah. Mm-hmm. It depends on whether you're a statutory filer or a code filer, and it can depend on usually just owning real property outside of the district won't have any effect. But if you were to have an investment in a company that does business in your district, then that would be something more likely to be disclosed. But again, it depends on whether you're a statutory filer or if you're a code filer and what your conflict of interest code covers. I don't know when owning property outside the district is something that's necessarily disclosed, but it would depend. I don't know if there's any situation in which you'd need to, but. So again, there can be things that you have to disclose, but only if they're relevant, and your code will determine if you need to or not. There are rules for gifts, and for statutory filers, the gifts have to be reported even if they're irrelevant or seemingly irrelevant. There are now special regulations for how to report gifts from multiple donors. So now you must only disclose the group gift only if if an individual donor contributed $50 or more per gift to the gift. So now if the group gift is over $50, that doesn't necessarily need to be reported as a gift unless the individual gave more than $50. But you have to keep track of the individual donors, because if they participate in several group gifts to you and they contribute $49 each time, then really aggregately they've given you more than $50, and that's a problem. So threshold for disclosure of gifts on Form 700 is $50 or more from a single source in a calendar year. And then there are other thresholds that will not only be disclosed, but then they will trigger actually disqualification. So now these are old numbers, and I apologize. I had a note to myself to check them, and I didn't see it when I was doing my final draft. So I'm not sure of the current numbers, but you can see that then there's something like more than $250 plus inflation from a single source in a rolling 12-month period. That can disqualify you from a governmental decision involving that single source. There is a limit that, again, I'm not sure about where the number is now, because sometimes they adjust these numbers, where you can't even accept that gift. Yeah. Yeah, if you go to the FPPC website, and you should be able to find out all that information. And if not, again, I have my cards here, so any follow-ups that you can't, if you still have a burning question, you can let me know that you weren't able to find the information, and I will find it, because I feel badly that I didn't have it for you tonight. Campaign contributions are not gifts, but they still must be disclosed on the forms. They don't affect the ability to participate in an elected capacity, but they may affect your ability to vote as a member of the board if you're considering a matter involving somebody that gave you a large contribution. Again, these are numbers that may be sort of old, that have to do with the amounts and then being disqualified from the decision. As I had in a previous slide, I don't know if I said it or not, but the conflict of interest codes have to cover consultants, and the rules with regard to consultants are kind of complicated, and the disclosures can be more limited than for the regular staff positions, but they do have to be included. So the recommended actions are to direct the chair of the board to work with staff to determine which independent contractors should be treated as consultants and what the responsible individuals need to disclose. This goes back to determining who's in charge of what, and so what is it important that we know that they have an interest in before they're allowed to make decisions. So the obligations regarding Form 700 are personal. It's not up to your board to make sure that you fill out the Form 700 correctly. It's you that has to fill out the Form 700 correctly. Good faith reliance on legal advice does not bar the Fair Political Practices Commission from pursuing action against you. The written advice from the FPPC about a question that you have is the only real safe approach. But saying all this, the form is difficult, but it's not that hard. You know what I mean? So unless you're really concerned about some distinctions, or you really for some reason don't want to disclose something that you think you might have to disclose but you're not sure, then you should be talking to the FPPC. But I don't want to make it sound so overwhelming. You probably, I'm assuming, have already filled out this form, so this should just be a review. I don't want it to seem like super duper scary. So now these are public documents, just remember that. And the filing officer must permit any member of the public to inspect any statement. So that is a reminder to you as the person filling out the form, and to any custodian of the forms themselves. And again, no information or ID may be required from the person seeking access. Reproduction fees of no more than 10 cents per page may be charged. The department can take longer to provide Form 700s if they are old enough to have been sent to storage. That's all about public access to it. Any questions? And we're done. All right. Thank you, guys. Thank you so much for coming. Again, I have my cards up here. I would also be interested to know if there are some topics that you would like to see covered in this kind of training, as opposed to something that we did cover or something we've covered in the past you'd like a refresher on, what you thought about what was covered. That would be very helpful to us. So, thank you.